Well, I am John Curry. I am the sales executive at the Balboa Park branch. We have three great escrow officers here, starting with our bulk escrow officer, who's kind of a unique offering that we have, Debbie Howe. And then we also have Gianna Pino and our branch manager, Donna Hamilton. One of our reps we are missing today. She is off. We have Jara Payne, who typically will cover the Rancho Santa Fe branch. And she has two escrow officers there, Stephanie and Kristen. So I'll leave it up to Tamara next, and then we'll do Marissa.
All right. Aloha, everybody. Good morning. I am Tamara Armstrong with the Temecula Heritage Escrow Branch. And I also I work with two amazing escrow officers, Carol Hankey and Chanel Jones. And I also want to introduce our Irvine office. We have Tara and Holly there in our Irvine branch. So anyways, thank you for joining us, everybody. Good morning. Marissa, you're next.
Yes, good morning, everyone. I'm Marissa Tour. I am the Carlsbad branch rep for Heritage Escrow, and I have two awesome escrow officers that I have the pleasure of representing. I have Holly Birch, she is the branch manager as well, and Anela Mirshara-Lindo. I do also want to highlight our Escondido branch as well with Alicia Bagby and Kelly Pinero. So thank you everyone so much for being here. I'm looking forward to this hour.
Thank you, ladies. So let's get everybody over to Schuyler. I have a quick little breakdown. He received his bachelor's degree in political science and Spanish from Davidson College in 2002. Sorry for dating you, Schuyler. And earned his Juris Doctor from California Western School of Law in 2007. During law school, he was named to the Dean's List and interned for Robbins, Umeda, and Fink, a securities law firm. Now Schuyler leads the residential real estate practice group at Hoffman and Ford here in San Diego. He represents clients throughout Southern California, focusing on legal matters involving residential real estate disputes, real estate non-disclosures, homeowners association conflicts, landlord-tenant disagreements, delays and liens, and fraud claims. And as Schuyler will tell you, him and his staff can pretty much handle any issue that may come up. So he's also going to have a little guest speaker pop on from his staff at the LEA. So Schuyler, stage is yours.
Thank you, John. Good morning, folks, and thank you very much for having me. As John indicated, Hoffman and Ford, we are a real estate-centric law firm. We primarily focus on civil litigation and transactional work, but with a focus on real estate, everything from a landlord-tenant dispute to a complex class action, construction defect litigation, mortgage litigation as well. And what I wanted to talk about today when I was broaching the issue with John about topics was new challenges that I've seen that have arisen as a result of largely of COVID, but COVID combined with cheap financing and very minimal housing availability. So I think a lot of you who are extremely experienced in the industry and were around in 2007 through 2010 and the fallout that we had as a result of that, then we kind of had a leveling out of things. We anticipated the 10-year cycle that we traditionally see to cause prices to start cooling down in 2019, but that actually never happened. Instead, with the rise of COVID, we saw a complete overthrow of the real estate market as a whole. You see a lot of folks who were living out in East County, who were up in Rancho Bernardo, Poway, 5-bedroom, 4.5 bath house, retired empty nesters. You see them moving to downtown high rises, and you see the growth that is now Little Italy, East Village, and associated parts of Columbia. Now what we're seeing is that with COVID, we're seeing that transition back. Folks, when you can't use your amenities and when all the restaurants are closed and ultimately downtown living no longer has the same appeal that it had before, we're now seeing that migration back to larger houses, multiple offices within a house, for example. Oftentimes you would have a couple bedrooms and maybe a dedicated office. Now you're seeing properties being advertised with multiple offices. You've got two breadwinners that are oftentimes working remotely now. And as a result of that, the demand has changed and it's affected marketing and pricing and all the like. People want a backyard. People want a pool. My pool contractors are busier than I've ever seen them. I want to install a new pool, and I'm not doing it anytime soon because I'm going to have to get in line with everybody else. So all these market changes, and particularly with the fact that while I'm looking out the window from Bankers Hill and I see a lot of cranes, that tells me in about 6 months to a year from now, we're going to see a lot more condo apartments built in this area. But in the meantime, as many of you know, at the $1 million price point and below, people can anticipate multiple offers on properties, a bidding wars to the tune that we've never seen before. And there's scenarios where you'll have 20 offers. There's scenarios where you'll put in 20 offers and your buyer's offer won't get accepted, or it'll be countered. And all of that, I think, has caused a bit of a frenzy and a bit of a panic. And as a result of that, escrows, once a buyer and seller do come to terms, it's happening a bit more haphazardly than we've seen in the past. There's such an urgency to get your offer accepted that buyers are coming in over asking. Buyers are coming in releasing certain contingencies that traditionally they would wait their 17 days, their 21 days. They're coming in, and in order to outbid somebody else, they are saying, I'll put in an offer now. I'm releasing appraisal, loan, inspection contingencies right out of the gates. And that, again, that's risky. But it's risky because of all the reasons that we traditionally associate with the benefits of having those contingencies available. And when you rush, that's when mistakes are made. And a couple examples of mistakes that I see commonly, for example, is if you know that your client's pre-approved at $800,000 and a property is listed at $799, there's a good chance in order to get that property, your client's probably going to have to go up to $850, maybe even $900. And never can I recall up until recently going on to the MLS, going on to Redfin or Zillow, and actually seeing notices that their prices are increasing. So an agent will list a property, perhaps at or below arguable fair market value, in order to obtain a bidding war, to have a bidding war take place, to now see that $800,000 listing going up to $850 or higher. And as a result of that, you've got to ask yourself, well, okay, my buyer was pre-qualified at $800,000, but now, because in order to get our offer approved, we got to go up to $850. Well, again, is your client buyer going to be able to make up that difference? And if not, are they putting their EMD at risk, their earnest money deposit, their security deposit, because they haven't done everything they need to do to make sure they can make up that difference? When you rush is when mistakes occur. And what I'm seeing, while DocuSign, folks, is all very convenient, when you consider the amount of money that that real estate is costing folks here in San Diego, I think it's incredibly important that while we have DocuSign, that sit down with your buyer, sit down with your seller, and make sure they understand the terms. A common thing that we see now that we haven't seen before are convoluted offers that involve escalation provisions. My offer is $680,000, and I'll escalate on a $5,000 increments up to $750, understanding that the seller is accepting multiple counteroffers. Well, when you have a scenario like that, you inherently create confusion, and confusion is problematic. The definition of a good contract, and you can't contract for everything, but what you can do is make a contract as foreseeable as possible. If A, then B. If C, then D. And while the use and reliance of car forms is beneficial, everybody needs to remember something. I can sell you a property on a napkin, okay? Car forms are not the end-all be-all. They are not the law. They are guidelines. They are a tool that assist parties in negotiating terms and proceeding through the escrow process, but they're not the end-all be-all. And in unique scenarios, use an addendum, okay? Utilize all the opportunities you have to create a unique contract that suits your client's needs. And to give you an example of what I'm talking about is now more so than ever, you'll see sellers agreeing to list their property, but there's a condition precedent. The condition precedent being, I need to find an alternative place to put a roof over my family's heads. Okay. Now, typically, that's not too tough, right? Back in 2010, 2012, you sell your Poway 5,000 square foot house, and it's not all that difficult to go find a nice empty nester condo in downtown. Well, now that's a lot more challenging than it was before. And everybody's needs are changing as well. People don't want to move out of their school districts. There's a consideration for, well, can I find another property that suits my family's needs? And what we've been seeing, and to give you an idea of exactly what I'm talking about, is in the last 6 months, my law firm has filed more quiet title specific performance lawsuits related to escrows that have been breached or otherwise fallen out. In the last 6 months, we've filed more than we have in the 5 years prior combined. We're probably suit to preserve status quo or to enforce a residential purchase agreement almost on a daily basis. Okay, that is a scary trend, folks. Okay, specific performance and the lis pendens that clouds title, that should be a last resort remedy. It should not be par for the course. And one of the reasons this is happening is because buyers and sellers are so eager and so motivated that they're not understanding exactly what the terms are of the contract and what it actually entails. So for example, the liquidated damages provision in the EMD. Now we all know that if it's under 3%, it's presumed to be an accurate measure of damages. And in the event the buyer fails to perform, remove a contingency after a notice to perform has been issued and not responded to accordingly, that a seller can cancel and a seller can presumably demand the EMD. Well, one thing that sellers haven't realized and rarely realized, because it's not articulated, folks, in the car forms or in the disclosures, is if I'm a seller and I plan on moving my family from Poway to Imperial Beach, and I'm in escrow, I've accepted an offer, but all of a sudden, in the middle of escrow, the Imperial Beach house I wanted goes off market, or for whatever reason, I can't find suitable alternative housing. If I have not contracted in a provision that affords me the right to get out of that contract, I could be bound by that. I could be compelled to sell my property under threat of specific performance. And that's a scary proposition, because again, the market is so unpredictable that you have to make sure that you're contracting properly around this. Everybody understands real estate transactions to be rush, 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 wait, 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 rush, rush, rush. Okay. What I would strongly recommend, more so than anybody's ever done in the past, is if you're going to put an offer in on a property, okay, pull a prelim first. At a minimum, pull a property history. Okay, if you see that the property's in trust or the property's owned by an LLC, then make darn sure when the seller provides either their acceptance or counter that you've got your representative capacity signature disclosure. I've got a couple cases I'm litigating now where there's two sellers or the property's in trust and one of the beneficiaries didn't like the sale price that the trustee was proffering, and now there's a dispute there. You've got scenarios, folks, where with COVID, particularly with the elderly, where you may have a seller that becomes incapacitated and it finds themselves in the hospital, okay, or possibly in quarantine. Well, how are you going to get your notary in there to get your grant deed and to sign closing documents when they're in the hospital? Or worse yet, they're incapacitated or possibly even pass away. So more so than ever, there needs to be more preparation going into escrow. Sellers should, in my opinion, sellers should have a TDS and SPQ, transfer disclosure statement, seller property questionnaire. Those should arguably be completed before you start accepting offers. And in that scenario, on day one after acceptance, you can furnish your disclosures. If you're in an HOA, don't wait around until an offer has been accepted to request HOA documentation. Some HOAs are taking forever to produce it. And a lot of the escrows we see now, a lot of the contract terminology and provisions that we're seeing that digress from what is traditional is we're starting to see consistently 21-day escrows. And then on the flip side, sometimes 40-day escrows. You'll see folks wanting to do 1031 exchange. But with all of that, how do you make sure that your escrow stays on the rails? And you do that by making sure your buyer is pre-qualified, that if there's an escalation, if there's a bidding war, and your offer ultimately gets accepted, that your buyer is going to be able to perform. And more so than that, well, great, interest rates are at an all-time low, okay? But at the same token, all lenders are extremely busy. So you need to go into the process understanding that there's going to be delays. There's going to be delays on the side of title. Escrow may be backed up a bit. And then with financing as well. There's countless times I've seen at the 11th hour, all of a sudden, the lender comes in and says, sorry, for whatever reason, we're not able to fund this. Well, how do you address that scenario when your buyer's released all contingencies and you've got $75,000 in EMD sitting with escrow? That's a challenging and problematic proposition. So make sure your financing's in order. Make sure your financing anticipates the potential for a bidding war. Sellers, make sure all your disclosures are ready. Listing agents, get your avid, okay? There's nothing wrong with getting an avid done today and listing the property 2 weeks from now, okay? As long as there hasn't been any material change to the property itself, then that's completely acceptable. But get your ducks in a row, because understand that there's going to be delays, but do what you can to try and mitigate those and avoid them. Another common problem that we're seeing is with investment properties, particularly investment properties in the sale of investment properties that have tenants there. You're seeing a lot of people that are no longer, a lot of owners that are no longer interested in being landlords. Landlord-tenant law, which is why I'm having one of my associate attorneys, Athalia, who specializes in landlord-tenant law. I'm going to have her come on in a couple minutes and speak more specifically. But taking, for example, with COVID and the moratoriums that we've all had to address, you've got extremely challenging times in the past 12, 18 months because you got to do an inspection, but the tenant is not allowing for entry. Or you have a tenant who's not paying rent, but you still have a mortgage on that property. These are all new, they've always been issues, but never, ever to the degree that we've experienced during COVID. And as a result, how do you address a tenancy with all the new protecting tenants' rights provisions out there, you've got to ask yourself as a prospective buyer, am I going to agree to close escrow with a tenant in possession, or am I not? And if I'm going to put the onus on the seller landlord to terminate that tenancy and remove that tenant, how feasibly are we going to do that? And in fact, is the seller going to be able to do that? And within what type of time constraints? So these are all considerations that, while many of them have been around for years and years and years, a lot of these unique circumstances are being heightened, and they're having a much more detrimental impact on smooth transactions than they historically have before. And the best way to avoid that is, everybody's rushing, but do your due diligence. Review prelims. Get your seller disclosures ready. Have your financing lined up. Okay? It's always rush, 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 wait. But do what you can to mitigate that. If you're going to add conditions precedent, i.e. a replacement property or removal of a tenant from an existing property, be sure your addendums to your contracts clearly and definitively lay out what those terms are. Do what you can to avoid ambiguity. When a contract is ambiguous, that's where guys like I get involved, and it gets expensive and it gets very complicated. So do what you can through the addendum process to make your contract as clear as possible. One example that I utilized on a property that I closed on my home on January 7th. Well, I was in escrow right after Thanksgiving, right during Christmas, right before New Year's. And admittedly, I didn't plan on this acquisition. I toured a property, I fell in love with it, and I put in an offer. Well, there were some challenges involved with that. I'm self-employed. It would have been easier had I literally worked for myself and been a W-2. But what I did in my particular transaction was, while it was a traditional 30-day, I afforded myself another 15 days utilizing a per diem. So if I didn't close by December 31st, 2020, I had another 15 days at a per diem of $250 per day. Now, I ended up closing on the 7th, and the per diem, yeah, I had to kick in more money, but it allowed me to, provided me the additional time I needed to perform, get my financing in order, and find myself in a scenario where my EMD wasn't at risk. You'd be blown away how a simple provision like that can clean up and afford a party additional rights and remedies that will allow them to get a deal closed. So provide yourself some outs when possible. And with that said, I think that's a good segue to introduce Athalia, who again is going to go into greater details on some of the issues that I broached, but specifically as it relates to challenges with COVID moratoriums and what everybody can anticipate moving forward. So I'll turn it over to you, Athy. And
Hi, everybody. Can you see and hear me okay?
Yes, we
Very
can.
good.
Well, good morning. My name is Athalia Magana. As Sky mentioned, I'm an associate here at his office. And a large part of my work is landlord-tenant law. And boy, have we seen the roller coaster the last year with respect to COVID and the problems with tenants and landlords. And the law has recently changed. Just a few days ago, actually on June 3rd, the San Diego County enacted a new ordinance that changes everything. But I'll kind of just briefly touch base on the issues that I've seen. We represent a lot of landlord-tenant clients, both on the landlord and the tenant side. However, most of the problems that I've seen end up being on the landlord side of things, and that's just because the state of California and the county of San Diego has just made it really difficult for landlords to cooperate with their tenants and figure out a way to sell their property or to get the tenant out especially if they're problematic. So the first thing that I just want to cover is when there's a tenant in possession and you're thinking about selling your property, it can become very challenging. And there's a number of reasons why. And it depends on the type of tenant we're dealing with. Sometimes a tenant is very cooperative and understands that you want to sell your property. It's important to note that a lease does not automatically terminate. So just because you're selling a property to a new buyer, it does not mean that the lease terminates with your tenant in possession. The lease just goes to the new buyer, and the new buyer is now the landlord of the property. Before this new ordinance came out with the San Diego County, you were able to, subject to certain extensions, there were some circumstances where you could use a signed RPA, open escrow, and agents identified as sort of a basis to remove the tenant. And that was only true in circumstances when the buyer wants to occupy the property as their permanent residence. So the buyer is going to move in, so the seller serves the tenant with a 30-day notice. They get 30 days to leave, and your proof of that is I have a signed RPA and escrow is opened and my buyer wants to live here as their primary residence. So that was one way we were kind of able to navigate the situation. And when you have a tenant that's not paying rent, it also becomes increasingly difficult because the tenants tend to argue that they're being evicted retaliatorily. So retaliatory eviction is essentially saying that the landlord is trying to evict you based on an ulterior motive. And the ulterior motive is I'm not paying rent. There are many tenants who have enforced their rights under the California law about not being evicted just for not paying rent. There are many tenants who are not paying rent. Unfortunately, that law ends, well, I mean, for many tenants, the law expires on June 30th, unless it is extended. So we're nearing the end of the non-payment of rent arguments and the non-payment of rent rights that tenants are able to enforce. The other issue I've been seeing is recently we had a case where a landlord was selling their condo and the tenant wasn't allowing the inspections to occur. Every time they would come in with a buyer and a contractor and the home inspection expert, the tenant would deny access to the premises. So on the face of that, and not considering any other ordinances that just came out, typically when that happens, tenants are not allowed to deny access to the premises. Yes, the landlord must give proper notice that they're coming in for the inspection with their buyer that they've already contracted to sell with. The same also goes for any prospective buyers that are looking to view the property. There is enough case law out there where the court has noted a listing agent can hold an open house even though there is a tenant in possession. It can't be every weekend, but it seems that the general consensus is a listing agent can hold an open house once a month. A listing agent can show the property to prospective buyers so long as it's in reasonable business hours. Reasonable business hours is defined typically in the lease. So if it's a typical car lease, reasonable business hours is defined as Monday through Friday, and I think it's 9 to 5. And even Saturdays and Sundays, I think it's from like 10 to 4. So you can take into account reasonable business hours doesn't necessarily have to be Monday through Friday. It's also Saturday and Sunday. And yes, you can hold open houses. Again, this is before this new San Diego County ordinance that came out a few days ago, and I'll touch base on that in a little bit. The best way we've been able to see tenants cooperate is offering a cash for keys. And the first time we mention it to our clients or landlord clients, they don't like it. I mean, why should they pay for the tenant to move out? It is their property. They have a right to do what they want. I completely understand that. However, it's a cash for keys provides many benefits. The first benefit is certainty. You don't have to deal with a tenant battle. You don't have to deal with your buyer wanting to back out because the tenant is still in possession. It provides you certainty that the tenant's going to vacate on a certain date, and in exchange, they're going to get some sort of incentive. The incentive can be a number of things. It can be just a check if they move out. It can be waiver of rent if you want to waive the next month that's coming up. It can be waiver of all the COVID rent, or at least a portion of it that they haven't paid if you're dealing with a tenant that hasn't paid rent and claiming a COVID-related financial distress. So there's several ways you can approach the cash for keys if you don't just want to give a check. Another way is saying, I'll give your security deposit back. So long as you don't bust my windows and trash my place, I'll give you the security deposit back in full. So those are some options that we give landlords when considering offering a cash for keys to the tenant. And the tenant seems to react well to a cash for keys because they're getting some sort of benefit. Tenants sometimes don't want to deal with new landlords. They don't know who they're, how the landlord is going to react. If once their lease is over, they may need to vacate. So the cash for keys tends to be a very attractive option to dealing with tenants that are in possession. The last thing that I would like to touch base on is the same goes for buyers. So that I just talked about, if you're selling a property, here are the problems that you can encounter. The same can go for buyers. So if you are a buyer that's looking to buy a property that happens to have a tenant in possession, as an attorney, I would tell them, be careful for the same reasons that the seller may be having issues with their tenant. If you are a buyer and you buy a property with a tenant in possession, now you're taking on all of those challenges that you might face if you want to move into the property, or if you want to eventually sell it, or if you want to put in another tenant in there instead. So there have been situations where I've advised clients, you should be very careful if you're buying a property with tenant in possession, because you're essentially putting yourself in the position where you can encounter a lot of challenges in this COVID world. So those are some of the issues that I would like to bring up. Now, it just got more complicated. The County of San Diego enacted an ordinance on, it came into effect on June 3rd, and it'll last 60 days after Governor Newsom lifts the stay-at-home order. And this new ordinance essentially limits the landlord's ability to terminate a tenancy. And I would like to differentiate what terminate a tenancy means to eviction. When you want to when you want to get the tenant out, that period of time where you serve them a notice, you tell them that you want them to vacate, that's called terminating the tenancy. So a landlord has a right to terminate a tenancy based on a certain number of reasons. Now, if the tenant doesn't vacate, then that can go to an eviction. So many times people confuse the two, and it's important to note. And the reason why I note the difference is because in the ordinances and under California, the California law, SB 91 and AB 38, the one that came out last year, it's important to realize what a landlord can do if it's terminating a tenancy or if it's evicting a tenant. There are different challenges a landlord may face depending on what they're doing with the tenant or to the tenant. So this new San Diego County ordinance limits a landlord's ability to terminate a tenancy unless there's a health and safety issue. So if you are selling the property and the buyer is looking to move in as their primary residence, you can't do that anymore. If a landlord is looking into moving into the property as their primary residence, you can't do that anymore under the ordinance until it expires. So right now we're looking at possibly August 14th. If Governor Newsom lifts the stay-at-home order on June 15th, then 60 days after that would be August 14th. That's kind of the time frame we're looking at. So then you turn to, well, are there any cash for keys options? And I would just say proceed with caution, because the ordinance is very specific. You could encounter issues if you do want to do a cash for keys. So, and I can see that there might be some questions. I don't want to go too depth and confuse everybody on what the ordinance says and doesn't says, because I can go all day on what ifs. So I rather just maybe spend the time answering some questions and specific questions you might have. Otherwise, we'll be here all day just saying this could happen, this could happen. The point of this is until this particular county ordinance expires, it's just become increasingly difficult to cooperate between landlords and tenants.
And to add just a bit on what Athlete was discussing, a common issue problem that comes up is when notices, either it's a 3-day, 30-day, 60-day, if it's a tenancy over one calendar year, oftentimes they're minor errors in the drafting of these notices. Now, understand something. No such thing as harmless error when it comes to a notice to terminate or a notice to vacate. If it's not exactly to code and tenant lawyers up, their lawyer is going to be able to get that notice to be rendered invalid. What does that result in? That results in having to start the whole process over again. Now, that can be pretty darn problematic if you're in escrow and you're set to close and you've got to issue a new 60-day notice. When it comes to landlord tenancy, time is money. And that's why, again, Athie's recommended to so many of our clients that we use the CFK, the cash for keys option, coupled with potentially a stipulation of judgment and arguably a writ of possession, because tenants have a lot of rights right now. Evicting somebody that is forcibly pushing back can be extremely difficult right now, and time is money. So again, make darn sure that whatever notices you provide are accurate. And a lot of property management companies don't have this right either. So again, make sure everybody knows what they're doing. Otherwise, there's a very big likelihood that you're going to have to start that process over again. And that can lead to a myriad of problems, specifically with a pending escrow.
I'm glad Sky brought that up, and thank you for bringing that. That is a huge issue. So unlawful detainer court is very black and white. The judge does not care what the tenant's hardship is or what the landlord's hardship is. All the judge all they care about is there a proper notice? Is it effective? Was it validly served? And is the tenant still in possession? If the notice is proper and effective and it was validly served and the tenant is still in possession, then the judge rules judgment against the tenant and to the landlord. If there is any small issue with the notice, then that can be deemed ineffective, and now your unlawful detainer case dismissed. Just like I said, now you got to start all over. You have to serve a new notice. And if you're dealing with something that's a 30 or 60-day notice, now you've just pushed back escrow another month or two, at least, because you still have to get a trial date, which in unlawful detainer court can be a little delayed.
In one way, one tool I've seen that should always be a step that should be taken when you're endeavoring to sell a property that has a tenant is buyer should obtain an estoppel agreement. Okay, the estoppel agreement requires that the tenant affirm what the terms are of the lease. Oftentimes, with a long-term tenancy, you'll have a lease agreement that's 5 years old, and it was originally a 1-year term, and then it's subsequently gone month to month. Okay, but it's important to make sure and clarify during the escrow process and to the fullest extent possible that if you are acquiring a property with it, even if that lease is set to expire soon after the close of escrow, that the tenant execute an estoppel agreement affirming the validity of that lease. Because commonly we see a tenant who says post-close of escrow, no, that wasn't the lease, here's the lease, or here's the email correspondence from 6 months ago between me and the former owner seller wherein they offered X, Y, and Z. Again, a way to avoid that is clarity and following the proper procedures of making sure that there's an estoppel agreement in place. So, Athy, anything else?
Yeah, and if you're representing a seller that wants to purchase a property with a tenant in possession, that's a question you should be asking if you're a buyer, that's a question you should be asking the seller. What are there any problems with your tenant? Because it's important to know what you're getting into, especially in in light of COVID. Do we know if there are any questions?
I do. I have a question, or there is a question that's come up in the chat here. It says, many sellers are staying for 1 or 2 months rent-free after close of escrow. Have you guys experienced any issues with that?
Where a seller remains in possession?
Yes. Yes. To answer your question, yes. And we've seen that consistently. For example, I had a couple cases where we had to get involved and draft a SIP, a seller in possession, but go into greater depth than what the car forms proffer. And in a particular scenario that occurred recently, that was largely correlated with the fact that sellers, again, their alternative property, they did not properly institute before listing that condition precedent that we need to be able to find and have close on a replacement property. We've got 3 kids. They're all in school. School's coming to a close in the next 2 months, but we are not going to uproot our family, move our kids out of the school district right before the end of the calendar school year. So in that scenario, what we did was, because remember one thing, if you're buying a property and intending to occupy as a primary residence, well, I bet you your lender documents are going to require that you assume possession of that property as your primary within 30 days of COE. If you don't, theoretically, you're in breach of your loan documents. Now, the reality is, as long as you're paying your mortgage, lenders rarely care where the money's coming from. That's just the nature of the business. But it is a significant consideration. And so what we did in that particular case was, as part of the negotiation itself, we offered the seller 30-day SIP without paying rent. And then we gave them another optional 60 days at a per diem, and the per diem was largely tied to the property debt service. So in that particular instance, property debt service, and by that I mean mortgage, property taxes, hazard insurance, HOA if applicable. You add all that up, and that way you've got at least your buyers covered, so they're not paying out of pocket while continuing to rent somewhere else for an extended period of time. Now, in addition there too, what we did was we added a significant amount of money that was held back at close of escrow. So we kept a security deposit for the seller, now tenant, that was 2 months worth of rent. So in the event that you had your 30 days free, you had an additional 60 days. And if they didn't pay during that 60-day period, we weren't scrambling to find money. We just simply weren't going to release the proceeds that were remaining post-close of escrow until they vacated. And there's other kind of escalation provisions that we oftentimes incorporate, wherein after the expiration of the 90 days, if that seller tenant hasn't vacated, we've issued a stipulation of judgment writ of possession. What does that do? It largely circumvents the unlawful detainer process to a degree, wherein the seller tenant has waived certain rights to defend. And while obviously everything can be challenged in court, what's most important in consummating a deal is that the parties understand going into it what their rights and what their obligations are. That's the best way to avoid conflict, is avoid ambiguity. Endeavor as best as possible to envision what possible complications may come up, because while all of these issues are common, historically, they've never been as pervasive as they are now. There haven't been the same degree of challenges historically as what we've faced now, because again, finding that replacement property has become infinitely more complicated than we've seen historically. So any other questions?
This one more of a statement, and we did touch on this, Sky, but that the lenders are, requiring that there be the buyer be in possession 30 days. I have seen 60 days here in escrow. So, but yeah, they're definitely making a point to. We had an addendum where they wanted to do 90 days, and they didn't accept that. So, yeah, there's definitely that going on with them.
And without getting too much into the weeds, there are often scenarios where perhaps we will agree to certain provisions, perhaps an extended SIP that aren't necessarily dealt with through the escrow process themselves. They're dealt separately through legal counsel, and because obviously oftentimes documents that are part of the escrow process themselves find their way over to the lender. There are scenarios where you may want to have a lawyer on both sides quickly review something and come to terms and agreement, such as the one I outlined before, that perhaps, while valid, aren't going through the traditional escrow. So any other questions?
I actually have a question for something Athalia mentioned that I'm just curious about. You had mentioned you have to give a tenant proper notice for inspections. And I've been on the phone with agents where they're like, the inspector's available, I gotta go. What determines proper notice? Because I just know that their schedules are so wild, it's sometimes hard to prepare for that.
Yep, 24 hours.
Okay.
24 notice. You have to tell the tenant what time you will be there and what the reason is. You can say a general inspection, but it's sufficient just to say, example, it's almost 11 o'clock right now. So you can say, I need access to the property tomorrow. You need to ask for permission. You just identify that you will need to access the premises at 11 a.m. tomorrow for a home inspection. That's all you really need to do.
And that's across the board. It doesn't have to be in the lease or anything like that. It's just a general law of.
That's a civil code requirement.
Okay.
But again, if the contract says otherwise, for some reason the contract says, and by the contract I mean the lease says 48 hours, then it would be 48 hours. 24 hours is the default. So again, the contract terms will always take precedence, which brings up another important issue. Is oftentimes we've been seeing, because of the rush everybody's been engaging in, you'll see your traditional boilerplate RPA provisions, and you'll see addendum terms that perhaps conflict as they relate to anything from deadlines for removal of contingencies to liquidated damages provisions to escalation clauses. When you have a boilerplate RPA and you have an addendum that was typed in or handwritten and executed as between and agreed upon as between the parties, if those terms conflict, the addendum language takes precedence. And the theory there is as we all kind of know, it's very rare for parties to read every single line item in the 10-page RPA, okay? I represent a lot of lawyers that don't even read the RPA. And again, while DocuSign is very, very convenient, folks, it's also very, very dangerous. We're all rushing. You're emailing your buyer, you're emailing your seller, hey, I just sent you a demand to perform. I need you to, or an extension of time. I need you to quickly get on your computer, hit the DocuSign button, push yes, send it back. Well, people are doing this, even sophisticated buyers and sellers, without giving it any thought. And when you consider the amount of money we're talking about, that's scary, okay? So what's important to understand, though, is when you have conflicting terms between an addendum and the boilerplate language you see in the RPA, the addendum terminology takes precedence. Any other questions?
Thank you so much, Sky. Oh, is this, yeah.
Okay,
So go ahead,
so
John.
everyone knows, I just added in the contact info for Schuyler's firm for anyone that may have questions that come up now or down the road.
And also too, I just want to tell folks that generally my office provides a free 10-minute consultation. I routinely on a daily basis will get calls from agents that I represent that are in the field. Hey, Sky, what do I do? You know, all of a sudden we found out that the HOA just entered construction defect litigation. Now the buyer is not going to be able to procure the requisite financing. What do we do? Or what do we do with a tenant that's not allowing us entry to the property or is holding over? Or I am not able to find a replacement property. What do I do? Those types of questions, believe it or not, if particularly at the outset, can generally be handled within a 10-minute phone call. What becomes difficult is unraveling a deal at the 11th hour when you've got a buyer who just packed up everything they owned and packed up their kids, gave notice to their employer, okay, and their truck, their moving truck is halfway across the country, and all of a sudden you're a seller, and for whatever reason you're saying, you know what, I'm not ready to make this move, and call their listing agent and say, you know what, issue your notice of cancellation. I don't want to push forward. Okay, this is happening every day, and it's largely because people don't understand their rights and remedies. Specific performance, which is a remedy for a buyer, which is generally extremely rare, because of the fact courts in general like to award damages. They do not want to engage in what's called equitable relief, which is requiring a party to do something or not do something. And specific performance is a very, it's a very impactful result, requiring somebody to have to sell, to have to move out. But we're starting to see this. And again, largely if it can be avoided, the best way to do so is get your ducks in a row early. You know, John, you brought up the appraisal and inspections. The first day your offer gets accepted, get on the horn with your appraiser immediately. What are your days of availability? When can we get you out there? If it's a 17-day contingency period, do not schedule your appraiser on day 15. Because if for whatever reason they're not able to get out there, okay, and you're scrambling, well, guess what? You may get hit with a demand to perform. And if you're not in a position to do so, you have to run the risk to maintain the contract of removing a contingency without all the facts you need for your buyer to make an informed decision. Or you could potentially be in breach, end up losing your client's EMD, and now everybody's really upset with how things turned out. So again, while it's always rush, wait, take the time ahead of time. Get your buyers, get their financing in order, operating with the assumption they may get into a bidding war. Sellers, make sure you got your transfer disclosure statement, your seller property questionnaire, your AVID, any physical inspection reports that you've already obtained. Make sure you've got all that ready to rock and roll and get it over to the buyer quickly. You know, generally you wait 5 days sometimes to get them over, or your seller doesn't even complete them until you're opening escrow. My advice now is get in front of the ball, okay? Be proactive. And then also too, to the fullest extent possible, operate under the presumption that there are going to be delays, whether it's a title issue, whether or not escrow's backed up, whether or not it's a financing problem, simply because lenders are so busy. Again, provide yourself out and make sure to the fullest extent possible that your contract is clear and that there's as little ambiguity as possible.
Great information, Sky. Thank you so much. Any other questions? If not, we've got all the information right here in the chat, guys, and we are recording. John, is there anything else?
No, I think that's, like I said, I put Schuyler's info in there. If anybody on here has any questions, feel free to reach out to the rep or their office directly. Schuyler and Athalia, thank you so much. We appreciate it. And yeah, we really hope there was some useful information in there for everybody. But as you can tell, very knowledgeable staff. You're gonna run into questions at some point. They're a great team to reach out to.
Yes, 10-minute free consultation. That's a big bonus. Thanks, Sky.
And you know what? The reality is, part of the reason for the free consult is because I want my agents to avoid speculation. Okay, can I cancel? Can I not cancel? That's a legal question. That is a contractual legal question. And I provide my agents and brokers coverage by being able to come in and opine legally on behalf of my agent or broker. These are your rights and these are your remedies. Their agents and brokers walk a very narrow path when they start opining on those issues. And again, part of it is informing the principals, making sure everybody understands, but also providing the agent and broker an avenue to get those answers, to get those questions answered. There's nothing wrong, and I do it every day, with saying, I don't know the answer to that, but I'll find you the answer. That's why every lawyer in my office has their own area of expertise. There are things about landlord-tenant law that, despite the fact I'm the managing partner of this law firm, I don't know. And when I come across those scenarios, I know to ask Athalia or to ask our estate planning attorney or our tax attorney. Again, that's, I think, is one of the benefits of my firm, is that, again, we have the resources to quickly provide answers to allow informed decisions.
Yeah,
Thank you again for
really
your time.
appreciate you.
Thank you, guys. Appreciate the opportunity. And again, we're here if you need us. Best of luck. And again, attention to detail. Come prepared.
Awesome. We look forward to your next escrow, everybody.
Thank you.
Thanks,
Thanks
guys.
for being
Thanks,
with us.
Athalia. Have a great
Thanks,
Thursday,
Athalia.
everybody.
Have a great
Thank
week.
you.
Take care.
Bye-bye.